Wisconsin has one of the more clearly regulated late fee frameworks in the Midwest, with specific provisions in both the state statutes and the administrative code that define what landlords can and cannot charge. The governing law is found in Wisconsin Statutes Chapter 704, which covers landlord and tenant relations, along with Wisconsin Administrative Code ATCP 134, which provides detailed consumer protection rules. If you're a landlord or tenant in Wisconsin, the combination of statutory law and administrative code creates a framework with real teeth. Let's start with the most important rule. Wisconsin Administrative Code ATCP 134.06 prohibits landlords from charging late fees that are excessive. Under ATCP 134, a late fee provision in a residential lease is considered unfair if the fee is not reasonably related to the landlord's actual costs and damages resulting from the late payment. This means the late fee cannot function as a penalty. It must reflect the landlord's genuine administrative and financial costs. Wisconsin does not impose a specific statutory dollar cap or percentage cap on late fees. There is no rule that says the fee must be under $50 or under 5% of rent. Instead, Wisconsin uses the reasonableness standard. The fee must bear a reasonable relationship to the landlord's actual damages from the late payment. What's considered reasonable in Wisconsin? While there's no bright-line statutory number, guidance from the Wisconsin Department of Agriculture, Trade, and Consumer Protection, which administers ATCP 134, and case law suggested that fees in the range of 5 to 8% of the monthly rent, or a flat fee that reflects actual administrative costs, are generally defensible. A fee that approaches 15 or 20% of the monthly rent, or a flat fee of $200 on a $700 rent, would likely be challenged as unreasonable. The landlord's actual costs include the time spent processing late payments, making collection calls or sending notices, additional bookkeeping, the time value of the delayed payment, and any bank fees or other direct costs incurred because of the late payment. Landlords who can document these costs are in a stronger position to defend their fee amount. Wisconsin does not mandate a specific grace period by statute. There is no state law requiring a 3-day or 5-day grace period before a late fee can be charged. The grace period, or lack of one, is governed by the lease terms. However, most Wisconsin landlords include a grace period of 3 to 5 days as standard practice, and some local housing authorities require a grace period for properties participating in the Housing Choice Voucher Program. Even without a mandatory grace period, the reasonableness standard under ATCP 134 effectively discourages charging a late fee on the very first day after the due date. If rent is due on the first and the tenant pays on the second, the landlord's actual damages from a 1-day delay are minimal. Charging a $50 fee for a 1-day delay is harder to justify as reasonable than charging the same fee after a 5-day delay when the landlord has incurred real administrative costs in following up. Wisconsin's ATCP 134 also addresses other fee-related provisions that interact with late fees. The code prohibits certain lease provisions deemed unfair, including provisions that require the tenant to pay the landlord's attorney fees in all circumstances, provisions that waive the tenant's rights under the code, and provisions that impose penalties disproportionate to the landlord's actual damages. A late fee provision that violates ATCP 134 can be declared void and unenforceable. The consequences of violating ATCP 134 go beyond just losing the late fee. The code is enforced as a consumer protection regulation, and violations can result in the tenant recovering twice the amount of the overcharge, essentially double damages, plus attorney's fees and costs. This means an excessive late fee doesn't just get thrown out, it can cost the landlord money in penalties. Compounding late fees in Wisconsin require careful attention to the reasonableness standard. If your lease charges a one-time late fee after the grace period, that's straightforward. If your lease charges an additional fee for each day or each week that rent remains unpaid, the compounding structure must still satisfy the reasonableness requirement. A daily fee that could accumulate to exceed the monthly rent within a few weeks would almost certainly be deemed unreasonable under ATCP 134. The interaction between late fees and the eviction process in Wisconsin works as follows. Under Wisconsin statutes, Section 704.17, a landlord can issue a 5-day pay or quit notice for non-payment of rent for month-to-month tenancies, or a 14-day notice for tenancies with a term of 1 year or less. Whether unpaid late fees can be included in the amount demanded on the pay or quit notice depends on how the lease defines the fee. If the lease defines the late fee as additional rent, it can be included in the total amount on the notice. If the lease treats the fee as a separate charge, the landlord may need to pursue it separately. Wisconsin has a specific provision regarding the return of the security deposit that interacts with late fees. Under Section 704.288, the landlord must return the security deposit within 21 days of the tenant vacating. If the tenant owes unpaid late fees, the landlord can deduct them from the security deposit, but only if the lease authorizes this deduction and the fees themselves are reasonable under ATCP 134. Deducting an excessive late fee from the security deposit compounds the violation. The tenant can challenge both the fee itself and the improper deduction. For tenants receiving housing choice voucher assistance, Wisconsin landlords should not charge late fees when the housing authority's portion of the rent is delayed due to the authority's processing. The tenant cannot control the housing authority's payment timeline. If the tenant's portion is paid on time, the late fee should not apply to the total rent amount simply because the authority's portion arrived late. Wisconsin's strong tenant advocacy community, including Legal Action of Wisconsin and the Tenant Resource Center in Madison, actively assists tenants who are charged excessive late fees. These organizations regularly challenge late fee provisions under ATCP 134 and pursue the double damages remedy. Landlords who charge fees that clearly exceed their actual costs should expect pushback. From a practical standpoint, Wisconsin's rental markets vary across the state, and the late fee dynamics differ accordingly. In Milwaukee, the state's largest market, late payment is a persistent issue in certain neighborhoods, and landlords rely on late fees as both a revenue source and a behavioral incentive. Milwaukee landlords must be careful that their fee structure complies with ATCP 134 because Milwaukee's active tenant advocacy organizations regularly challenge excessive fees. In Madison, where the rental market is tight and heavily influenced by the University of Wisconsin, late payment is less common among the student and professional populations. Madison landlords typically use moderate late fees as an incentive for on-time payment rather than as a significant revenue source. Green Bay, Appleton, Kenosha, Racine, and other Wisconsin cities have moderate markets where late fee enforcement varies by landlord. The ATCP 134 reasonableness standard applies uniformly across the state, regardless of market conditions. One best practice for Wisconsin landlords: document your actual costs associated with late payments and set your late fee based on those documented costs. If you can show that a late payment costs you $45 in administrative time, bank fees, and follow-up communication, a $50 late fee is well supported. If your documented costs are $15 and you're charging $100, you're exposed. Another best practice: include a reasonable grace period in your lease, even though Wisconsin doesn't mandate one. A 5-day grace period demonstrates good faith, gives tenants a reasonable buffer, and makes your late fee more defensible if challenged, because the tenant had a meaningful opportunity to pay before the fee was imposed. A third best practice: never charge a late fee without a clear written provision in the lease. An oral agreement to charge late fees is difficult to enforce and creates disputes. The lease should specify the rent due date, the grace period, if any, the exact fee amount when the fee is triggered, and whether the fee is defined as additional rent. For the complete guide to Wisconsin late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.